Judgment in the matter of McCulloch and others against the Forth Valley Health Board.
Lord Burrows will explain this judgment.
This case is concerned with the extent to which a doctor is required, under the duty of care owed to a patient, to inform the patient about alternative possible treatments. It explores the scope of the duty of care to inform that was laid down in the seminal case of Montgomery against Lanarkshire Health Board in 2015. Neil McCulloch died of a heart attack, aged 39, on the 7th of April 2012. His widow and other family members have brought this action, alleging that Mr McCulloch's death was caused by the negligence of Dr Labinjoh, a consultant cardiologist at the Forth Valley Royal Hospital. Mr McCulloch was first admitted to that hospital on the 23rd of March 2012, complaining of chest pains, nausea and vomiting. Dr Labinjoh's first involvement was a couple of days later when she was asked to review an echocardiogram that had been performed on Mr McCulloch. Her review of Mr McCulloch indicated that his presentation did not fit with a standard diagnosis of what is called pericarditis, which is an inflammation close to the heart. During the next few days, Mr McCulloch's condition improved and he was discharged home on antibiotics on the 30th of March. But a couple of days later, on the 1st of April, he was readmitted to hospital, complaining of chest pain as before. He was given intravenous fluids and antibiotics under the care of the medical team. On the 2nd of April, there was a nursing entry saying, "nil further chest pain." Dr Labinjoh visited him in the acute admissions unit on the 3rd of April, having reviewed a further echocardiogram. He looked much better than when she'd previously seen him, and in answer to her questions, he denied having any chest pain. Dr Labinjoh was not the consultant with overall responsibility for the care of Mr McCulloch, and from the perspective of her role as a cardiac specialist, she saw no reason to prescribe any additional medical treatment. In particular, and central to this case, she did not regard it as appropriate to prescribe a non-steroidal anti-inflammatory drug such as ibuprofen because Mr McCulloch was not in pain at the time she saw him and there was no clear diagnosis of pericarditis. So the reason she did not prescribe a non-steroidal anti-inflammatory drug, which for shorthand I shall refer to as a non-steroidal, and did not discuss taking such a drug with Mr McCulloch, was because in her professional judgment, prescribing a non-steroidal for Mr McCulloch was inappropriate. Mr McCulloch was discharged home on the 6th of April and remained on antibiotics. On the 7th of April, he suffered a cardiac arrest at home from which he died. Alongside issues of causation, the central question in this case was whether Dr Labinjoh was in breach of her duty of care by failing to inform Mr McCulloch that a possible treatment option for him was a non-steroidal. It's alleged that had he been so advised, he would have taken a non-steroidal, and had he taken a non-steroidal, he would not have died. According to the expert evidence, while some doctors would have prescribed a non-steroidal to Mr McCulloch, there was also a responsible body of medical opinion that supported Dr Labinjoh's approach, given that Mr McCulloch was not in pain and there was no clear diagnosis of pericarditis. The lower Scottish courts, that's the Lord Ordinary and the Inner House, held that Dr Labinjoh was not negligent in failing to inform Mr McCulloch about the possible treatment by a non-steroidal. The widow and family members of Mr McCulloch now appeal to the Supreme Court. The Supreme Court unanimously dismisses their appeal. The judgment is given by Lord Hamlin and myself, with whom Lord Reid, Lord Hodge and Lord Kitchen agree. Our reasoning is that following what was said in the Montgomery case, there is a duty of care to inform the patient of all reasonable alternative treatments as opposed to all possible alternative treatments. The correct test to decide what is a reasonable alternative treatment is what can be referred to as the professional practice test, which was set out in the context of diagnosis and treatment in the cases of Bolan in England and Wales and Hunter and Hanley in Scotland. What this test means in the context of information is that a doctor who has taken the view that a treatment is not a reasonable alternative treatment for a particular patient will not be negligent in failing to inform the patient of that alternative treatment if the doctor's view is supported by a responsible body of medical opinion. A hypothetical example may help to explain in more detail how we regard the law as working. A doctor will first seek to provide a diagnosis, which may initially be a provisional diagnosis, having, for example, examined the patient, conducted tests, and having had discussions with the patient. Let us then say that in respect of that diagnosis, there are 10 possible treatment options. Let us then say that the doctor, exercising his or her clinical judgment and supported by a responsible body of medical opinion, decides that only 4 of them are reasonable. The doctor is not negligent by failing to inform the patient about the other 6, even though they are possible alternative treatments. The narrowing down from possible alternative treatments to reasonable alternative treatments is an exercise of clinical judgment to which the professional practice test should be applied. The duty of reasonable care would then require the doctor to inform the patient not only of the treatment option that the doctor is recommending, but also of the other 3 reasonable alternative treatment options, plus no treatment if that's a reasonable alternative option, indicating their respective advantages and disadvantages and the material risks involved in such treatment options. It was submitted by counsel for the appellants that the professional practice test was not the correct test to apply, and that it's for the court to determine what are the reasonable alternative treatments about which the patient should be informed. But the Supreme Court rejects that submission for a number of reasons. First, consistency with what was said in Montgomery. Secondly, consistency with the 2-stage test set out by the Court of Appeal in Deuce and Worcestershire Acute Hospitals NHS Trust. Thirdly, consistency with medical expertise and guidance. Fourthly, avoiding an unfortunate conflict in the doctor's role, in the sense that acceptance of the submission might lead to a doctor having to inform the patient about a treatment that the doctor, supported by a responsible body of medical opinion, considers to be clinically inappropriate for the patient. Fifthly, avoiding bombarding the patient with information. And sixthly, avoiding making the law uncertain for doctors who have to apply it. In essence, the Supreme Court rejects the submission of the appellants because it would constitute an unwarranted extension of the law on the duty of care to inform that was laid down in the Montgomery case. Applying that law to the facts of this case, Dr Labinjoh was not negligent because her view that prescribing a non-steroidal for Mr McCulloch was not a reasonable treatment option for him because he was not in pain and there was no clear diagnosis of pericarditis was supported by a responsible body of medical opinion. She was therefore not in breach of her duty of care by not informing him of that possible option. The appeal is therefore dismissed.
The court will now adjourn.